there are couple of points which have been taken and that was identical, so I won't be touching the same. All points by Mr. Mitro, my lord. In fact, I also had in my mind, I'm not gonna touch it. Address on a very fundamental point of view. Mr. Bhattacharya, in my understanding, is trying to portray a picture of the world where either there black exists or the white exists. In other words, I said metaphorically this part. In other words, the word void, null and void in the Supreme Court's order, it's so clear, so watertight that it cannot be tweaked. Either Supreme Court having declared null and void, does it mean that Supreme Court has also said whatever is also attached with the all the candidates minus the tainted? Because well, I'm not appearing for the tainted, so tainted it's done. Kindly look at from this point of view. I do not say that in a particular situations the court cannot declare something to be void, null and void, and the consequence of the same means absolute zero, no experience out of it. It can be. But contrast it with the situations, having said null and void, the same Honorable Supreme Court also said and felt for us, in a sense, saying that who are working somewhere else, they will also be able to resume their duty, number one. In other case, Lordship, kindly take paragraph number 47. Lordship will see the meat path being taken by the Honorable Supreme Court. It's not black or white. Yes, selection process has been found to be illegal, right? Does it necessarily mean that all the fair candidates who have put in labor, who have received money, and who have also, my lord, whatever experience they had, who have done the teaching experiences, does it automatically go from their experience? To that effect, there is a clear answer by the Honorable Supreme Court in paragraph 47. Well, the copy is there, possibly with your lordships. Kindly take 47.
Supreme Court judgment is not here.
It is.
Yes,
আচ্ছা দেখি।
That's the main judgment. Mr. Bhattacharya has read out 45, so I am not reading 45. Now kindly see 47. That is the tweak and that's the middle path. And recognition of, I may not use the word sympathy, but that what we suffered is a collateral damage. We are honest. Now that was acknowledged.
And the
Kindly see-
list I would like to see.
Yes.
The tainted and untainted or something. How this had been published.
That they
You
would
do not know, commission will get.
So far as we are never been in the list of that. That's for sure. 47, kindly see, some of the appointed, Lordship has taken 47. Some of the appointed candidates who do not fall within the category of tainted candidates. So this is a first tweak. May have previously worked in different departments of the state government or with autonomous bodies, etc. In such cases, although their appointments are cancelled, these candidates will have the right to apply to their previous departments or autonomous bodies, kindly mark the word, to continue. Well, there is a difference between the words to begin fresh and to continue. And to continue is the recognitions. Yes, we have to no other alternative, but we also recognize that you had a service and thereafter kindly see, to continue service with those entities. These applications must be processed by the respective government departments or bodies within 3 months, and the candidates will be allowed to resume their positions. So just like us. Now kindly come to the other point, leaving aside Supreme Court judgment. If I put a question to myself, can prior teaching experience be a criteria? Well, can't you take any professions anywhere, even in our profession also? Experience is an age versus someone who has got the educational qualification. If the authorities feel that, and there are variety of rules and also recognized by the Supreme Court in some judgments also, that having a paper degree is one thing, which is a prerequisite. At the same time, if someone also has in reality an experience of teaching students, giving marks for that, to my understanding, well, this is absolutely valid and legal. Yes, that there could have been a complete block had the Supreme Court, have the Honorable Supreme Court, while referring to judgment, this is a meat path. Just because the word void, that void is in respect of the selection process, not void in respect of the money we have received, not void in respect of the experience we have had. Now that has happened, that is, in my words, it's a middle path. After recognition that we have suffered without being tainted persons. Kindly see, Mala, thereafter the most important word. Further, the period between the termination of their previous employment and their rejoining will not be considered a break in service. So recognition. So if Lordship kindly take a one extreme view, that void means zero. So there cannot be a continuation of that. Thereafter, their seniority and other entitlements will be preserved and they will be eligible for increments. So therefore, if I'm honest, if I happen to be in a society where unfortunately there was a selector who was corrupt enough and I suffered, so the Honorable Supreme Court recognized my suffering as an honest person and therefore tried to preserve the experiences that I have put in. In other words, if I put one sentence, in other words, the judgment of the Honorable Supreme Court does not say that because we have declared it to be void, that means everything zero. That means all the teaching experiences that we have done, that comes to zero. That is not. Then this continuation seniority would not have come. Now, second point comes, this issue, well, it was, the matter is pending before the Honorable Supreme Court. What I find is that in Orunima SLP, Mala, I have the soft copy, page number L. I am reading out the exact portion. Soft copy of the SLP.
Orunima Paul?
Yes,
The
not,
SLP
the,
copy.
not the order. I'm referring to the
Alright.
soft copy of the SLP, my lord. I will hand it over.
Probably was
Page number, yes, page number,
4 and
yes,
38.
page number L. Well, this is one sentence. I just read it out. Further, there was an extra 10 marks for teaching experience in the new rules, which automatically affected the candidates like the petitioners who could not teach due to the fraud played by the State Commission Board. So, my respectful submission before your lordship is this. As an honest candidate, I have already suffered. We have already suffered. Because we live in a society where there is a corruption. Even if we are not corrupt, we lose our job after so many years. After that, now lordship would be not taking the matter just a matter of technicality.
Yeah.
Also, lordship would deliver justice. Justice to all. As a candidate who have been found to be not tainted, who have served from, my lord, this 2016 recruitment process, and for the system who have lost, and they have lost because of the judgment where seniority has been preserved, money have been preserved. Now state has framed and come up with a rule that this experience, I'm not saying this, any experience, because it's not just us, anybody who has the prior teaching experience, they will get an X marks. Is it really so ultra virus to Article 14? And my respectful submission before your lordship would be, it is not. Kindly have a look at this judgment of the Honorable Supreme Court. This is 2017 11 SCC 421. There, first lordship, kindly take paragraph 16, paragraph 16, paragraph 17, and then paragraph 21. This is, here the word is, well, the weightage for experience. And kindly see on 21, irrespective of the whether weightage was from illegality or legality.
All right, 16, please,
Yes.
please.
Kindly see 16, in the circumstances, the members of the appellant union are entitled to know the result of the such and such. All that the learned single judge directed was to conclude the process and declare the result after giving such weightage to the past service of the members of the appellant union as the first respondent deemed fit and proper, which the Supreme Court also granted in paragraph 47. Now 17. We do not see any error in the directions given by the learned single judge, and we are of the opinion that the division bench is clearly in error in interfering with the said direction. Now kindly come to 21. The first respondent who was a party to the settlement recorded by High Court in its order dated such and such could not be permitted to raise the question of the enforceability of the settlement. More particularly, when all that the appellant seeks is only weightage for the past service of his members, which the first respondent agreed. in principle, well, I am on principle, to give to similarity situated persons working with other departments. The member of the appellant union have been working with the first respondent for long periods, period varying from person to person. Whether such employment was regular or irregular in law, in a different matter, the fact remains that their service were used by the first respondent. All my respectful submission before your lordship is this: once the Honorable Supreme Court in the main judgment recognized the past service for the honest candidates, framing of a rule by the state, not for honest, for everyone, recognizing the past experience as a teaching is absolutely not violative of Article 14 of the Constitution of India. My lord, I would just conclude by saying, because the points of Orunima, that this point, in fact, my lord, lordship may also think that this is a unique situation, because this is a kind of matter, unlike other matters, once the matter is over, my lord, Supreme Court usually puts a full stop. Now, this matter, the Honorable Supreme Court wants to see that entire selection process is completed by a particular date. So therefore, and my instruction is, this point was not instruction, it's also there in the Orunima SLP. This point was taken, which was, my lord, ultimately not found to be accepted by the Honorable Supreme Court. And that is the reason they have come lately questioning, my lord, the virus of this prior teaching experience. So I would conclude by submitting that, firstly, this is intra-virus. Secondly, the word void should not be looked into from an extreme interpretations, because in the light of paragraph 47, past service for the honest is a recognition. And thirdly, this point was taken before our bench, division bench, and ultimately have shown the SLP also, and not found favorable. So therefore, my lord, lordships may not pass a favorable order for the petition. These are my respectful submission.
So far I am concerned, my lord, can number 2, I am accepting the submissions of Mr. Mitra. Only thing is also I give the copy of the SLP. Can you see the point of law number 12 and ground number 12? It has assailed the very awarding of prior teaching experience. And the Supreme Court said no ground for it. No good grounds for it. So therefore they cannot take it. And more particularly paragraph 7 will also take note of this. And sequence of sentences. The paragraph 7 they say the online application was made, we participated, then we approach the authority for taking the application. So they had everything within their mouth.
in the month of October.
And the rest of the recruitment notification. Paragraph 7 of the these are my answers.
ওদের অ্যাপ্লিকেশনটা আছে
এই তো দেখো you want to get
Commission
আমি for the question I
would like to see the list, tainted and untainted, how you have given the preamble of that list. What is the note?
keep it at 3 p.m. will come with the list.
It is not necessarily you have to come today itself, because I do not want to hear the reply of the petitioner today. I will go through all these things. I will require the list. And the petitioner will reply on the next day. The queries that is passing through my mind, I'll put forth so that everybody can come.
In order to assist the court,
Yes.
first things.
sir এই ম্যাটার গুলো তাহলে
The first judgment was delivered by the Honorable Supreme Court from the appeals carried from the division bench's order.
That is here.
The thicker judgment, paragraphs 49, 15, we looked into. After that, the West Bengal Board of Secondary Education, citing, dearth of teachers.
Paragraphs 49 and 50.
Yeah.
Yes.
Now, citing, the situation likely to be faced by the students, had moved an application, and ultimately, as my learned senior friend, my Mr. Anindu Mitra, pointed out, the Supreme Court regulated the entire process, saying that this has to be done by this time, that has to be done by that time, everything has to be completed by 31st. Now, today your lordship is looking into a petition which was, admittedly filed on 1st of November, 31st October, 1st of November. It was taken on record. Now, this writ petition apart from anything else, suffers from gross and unexplained delay. And it is at the instance of persons, my lord, who, knowing fully well the terms of recruitment, participates in the process, my lord, knowing fully well that these are the particulars that they are likely to be fulfilled and they are not likely to be fulfilled. My lord, had they been so vigilant over their rights, then, my lord, perhaps, my lord, in Orunima, my lord, Orunima is one set of untainted candidates. Today, I don't find any averment. I take it. I don't find any averment in the writ petition as to who the writ petitioners are, apart from saying that they are eligible to participate. I take it they are also equally untainted candidates, but who were not recruited previously. Similar was Orunima. The fact remains, in Orunima, whatever the stand was taken, same prayer was sought to be foregone. A bunch of writ petitions was taken up. A point may be taken, that Orunima did not say that I am not pressing the prayer, but some other writ petitioner did. The prayer for declaration of the rules to be ultra vires was not pressed. It is deemed. Thereafter, the matter travelled to the Honorable Division Bench. Mr. Bandopadhyay, appearing for the state, has invited my lord to paragraph 28. My learned senior friend, Mr. Mistro, invited your lordship's attention to paragraphs 3, 4, the submissions. My lord, apart from that, once again, my lord, please have a look. I need not read it, my lord. Paragraph 35, what the Honorable Division Bench felt that in judicial review, whether that, my lord, can be 34, of course, and 35 thereafter. My lord, what can be done? What is permissible limits of judicial review? Now, my lord, today, looking at the entirety of the matter, this order of the Honorable Division Bench, at the instance of Orunima Pal, travelled to the Honorable Supreme Court. My learned senior friend invited your lordships to the grounds. This Honorable Supreme Court was definitely aware about the grounds, and ultimately, my lord, the Honorable Supreme Court, by rejecting the SLP at the threshold, there is no merger. But what happens is, my lord, the division bench's verdict remains. Now, my lord, a collateral challenge after July, August, September, no challenge, nothing. The examination is permitted to take place. The examination is held. My lord, they are stopped, if I may say so, my lord, with greatest of respect, from challenging after participating in the entire process, knowing fully well about, my lord, what are the possible consequences. Just to, my lord, negate today, the publication is in the offing. In today's morning matter, your lordship wanted us to take instructions. Kindly visualize, my lord, the attempted recourse to a proceeding under Article 226 also has to, my lord, satisfy the fundamental test of delayed recourse to a proceeding under Article 226. Someone who is indolent or an acquiescent litigant, who acquiesces with the entire thing, who accepts Orunima, and he doesn't carry or she doesn't carry anything beyond the dismissal of the SLP by way of a review. Whether it is entertainable, maintainable is another thing. But the fact remains, now another round of challenge, just to prevent the selection process, which has been, my lord, earmarked by the Honorable Supreme Court to reach its logical conclusion. A writ petition is today filed just to prevent the commission from doing whatever is supposed to be done.
Very well. The list,
Yes.
please bring.
My lord, I will. My lord, just see, if your lordship.
I don't want the names. The manner in which it has been published is required. Names, the court is not concerned.
No, we have it. Just give me 2 minutes. Okay.
All right, you make a printout and give. That is all right.
Your lordship,
I
will be tomorrow.
Not tomorrow, next week.
Another matter is fixed, my lord.
10?
No, we,
Another 2 or 3 matters.
All right, then Monday I can keep it. The earlier ones which were filed, please give the numbers also so that they can come.
your lordship will keep it on 12th. Mr. Bandopadhyay is leading me. Now, if he can assist your lordship's court in the event he's.
Zoning matter.
Other matters have been kept on 12th.
Some has
Some are
been,
10.
some it has been mentioned kept on 10th, but then I don't mind keeping it on 12th also.
Yes, my lord.
Let it be hard out.
Yes, 12th.
All the matters, my lord.
None is without, on the issue, with the best of respect.
Then, my lord, my point of dimmer also need not be kept open. Since you're also keeping on 12, let them also serve the learned advocate general in the meantime. Because
All right, all
I
right.
made the submission with my dimmer.
All right, all right.
দাদা এইটা একটু নিয়ে নিন তো।
You will give me the,
Kindly
Manner-
indicate in my lord's order.
I'll mention it,
Yes.
the manner in which
দাদা,
it has been published, right?
Manner in
Names, a
Very-
preamble,
very-
that
very-
is
very-
important. The names are not concerned. I'm not concerned with the names.
Tainted, untainted. I am concerned with fresh candidate.
I have followed your submission, but then the court, for the purpose of taking into consideration the Orunima Paul's judgment, all these things,
Kindly visualize. Orunima Paul threw a challenge to various issues, including marks. This writ petition is only restricted to marks.
একসঙ্গে
I could have understood that this writ petitioner Bhim approached the court along with Orunima and could have segregated his writ petition so as to invite a decision from the court specifically on this issue. Today, by filing a writ petition in the month of November and suggesting
so that is the reason I wanted the earlier writ petitions also to come on board.
earlier writ petition is already.
Let all.
So they say some are paid.
No, on this issue, no.
I do not.
No, on this issue.
Age of those other petitions are also put the same. They may be 1 or 2 days older.
There are some
They are nothing from me.
All right, let us see.
I am averse to the cacophony.
No, yes, let us see.
Risk is there, document
Yes.
will speak, and without, let us argue on the question of law, not being swayed by tainted content.
Yes, yes.
The question of law has
One minute.
been suggested.
1 minute.
Formal order for the addition.
I will. Mr. Bhattacharya, I would like a reply on the issue of Orunima Pal, the estoppel issue. Something else,
Doesn't arise, they're different petitions.
yes, I get that.
But there has
And something else is also playing in my mind. The principle of obiter dicta will also be required. You please bring certain judgments on this.
Question of constitutionality of objective has an answer.
Very well. Please be prepared with this and the judgments and everything. Please.
My lady, just one point if I may make.
Yes, madam.
Yes, if I may make one point.
And who are you appearing for?
Logistically. My lords, my lady, I appear for successful candidates, untainted, and we are before my lady. We have taken the exam successfully. We are only here to say 2 things.
Is
One,
there any
that the-
application on your behalf?
Yes, it's CAN 4, my lady. It's been filed as an
Alright, it's
implement
not there in the
application,
list.
CAN 4. CAN 4. But may I just make 2 points, my lady? One,
Has not been
One, my
served.
lady, in Sanjay Doloy, where 2 judges of my lady's court, the Calcutta High Court, actually heard this question and said that the policy, this is a policy decision, prior work experience being considered and being awarded 10 marks. Because you get more senior teachers, you get more experienced teachers, and that the judiciary should not travail into what is clearly legislative policy. One. Second point, my lords, is Sanjay Doloy's judgment was confirmed by the Supreme Court in July of this year. So that has attained finality. The third point is this, my lords, that this prior experience criterion, 10 marks, prior experience being given, is actually quite the norm. The UGC regulations on minimum qualifications for appointment of teachers 2018 also has prior experience as a criterion for recruitment. Very similar to what is before my lady. So this prior experience category cuts across the board when it comes to teaching and has been upheld in multiple high courts, including my lady's high court. So these are just the 2-3 points. And of course, my lady, I'll appreciate the opportunity of assisting on the next date.
All right.
I'm so grateful, my lady. I'm very grateful.
CAN 4 has not been served. Kindly request.
Yes, my instructing counsel
kindly
will
serve.
serve CAN 4. Please serve
Code is
CAN 4.
not there in the list
Oh, actually,
also.
it's not there in the list. Oh, actually, very good.
খাল
It's only CAN 1 which is here, 2 and 3 is also not here, and
Four,
4
four
is not
copies.
listed.
My lady, I believe it's been
service.
filed today.
Please serve CAN 4, all the parties.
Yes,
আমিও সার্ভ
please serve
করেছি
CAN 4.
We don't get the cost title when we go to different forums.
2 আর 3 ও এসছে তো 2 আর 3 আসেনি 4 চলে এলো আচ্ছা
I'm grateful that my lady heard me. I'm grateful.
ব্যাপারটা হচ্ছে এই পরে ফাইলে যেটা দিচ্ছে
Please serve CAN 4. Yes.
পুরো
জীবনের প্রথম রিটে আমি তোমাকে হারিয়েছিলাম, প্রথম রিট
হেরেই আছি, আমি তো জিতি না।
এইটার পরে আমি কনফিডেন্স হয়ে গেছিলাম।
The certain provision of the
I'm taking lots of.
recruitment, but then you are supposed to stay, isn't it, in that other matter?
I'll come from the morning.
No speaking.
Recruitment notification dated 29th May 2025, published by the School Education Department, is impugned in the instant writ petition. Stuff. More particularly, the weightage of marks provided for prior teaching experience is challenged. Stuff. According to the petitioners, the same is contrary to Article 14 of the Constitution of India. Stop. The notification seeks to create a class amongst a class, which is impermissible. Stop. Paragraph. Three connected applications have been filed seeking intervention. Stop. The applicants and the respondents in the writ petition oppose the submission and the prayers of the petitioners. Stop. The matter has been heard to some extent. Stop. The petitioners shall reply on the adjourned date. Stop. Next paragraph. Let a copy of all pleadings be served to all the parties. Stop. As there is a challenge to the vires of the rules, comma, let copy of all documents be served to the learned Advocate General. Stop. The matter is made returnable on 12th November. Stop. Learned Advocate representing the Commission is directed to produce the preamble of the list published by the Commission relating to the tainted and non-tainted candidates. Stop. Kurun, published by the Commission in compliance of the direction passed by the Honorable Supreme Court.
Submitted to.
Anything more to be included in the order for anybody?
No.
No, this will suffice?
Yes.
Service direction is there and the list to be.
Point B kept on.
Formally allow the
That is.
Lakshmi, add one line that this additional
Then later
paragraph
on they
can
will say
1,
we
2,
did not
3,
add.
whatever are there.
It will be taken up for consideration. The numbers will be there in the order sheet.
সব থাকবে।
So all are being heard together.
Yes, that's my only reason is that this matter most likely it will travel. Most likely.
Certainly, not most likely. Oh, arekta jinis.
Either way.
Arekta
As
jinis.
now,
Has been
It has been
that
brought
ve-
to the notice of the court that several writ petitions on similar issue is pending consideration.
Get police.
Stop. Let all the writ petitions be placed on board on 12th.
আচ্ছা,
Learned advocates are
ভালো।
requested
দাদা
to
আমার ম্যাটারটা নিয়ে নিন।
supply the writ petition numbers to the officer attached to this court for enlistment.
Now the question of maintainability be kept.
আমার can.
The issue of maintainability, as raised by the respondents, is left open.
224447.
Anything else? No.
1 9